Good morning, everyone. Welcome to the Appeals Court. Let me introduce the panel. I'm Justice Shin. To my right is Justice Brennan, and to my left is Justice Hodgins. And we will be hearing all 6 cases on the list today. As I'm sure many of you know, the rules of oral argument are that each side has 15 minutes to argue. When the yellow light goes on, you should think about starting to wrap up. And when the red light goes on, it means your time has expired. And we do not allow rebuttal in the Appeals Court. And the last thing I'll say is that the panel has read all the briefs, and we are very familiar with the issues and the facts in the record, and you should feel comfortable getting right to the heart of your argument. All right, so with that, I will call the first case, which is Commonwealth versus Jean-Louis, number 23P63. And this case is partially impounded, so if counsel could just avoid revealing the impounded information. Attorney Rossio.
Thank you. Good morning, Your Honors, and may it please the Court. Luc Rossio for Junius Jean-Louis. And I do want to recognize as well that Mr. Jean-Louis' wife is here attending argument while observing the proceedings. Before the Court today is a de novo review of a denial of an evidentiary hearing on a Rule 30 motion pertaining to 2 issues. I do want to emphasize that it is a de novo review. That's under Commonwealth versus Mazza, 484 Mass 539. It's de novo because the judge who denied the evidentiary hearing did so on the papers, and he was not the trial judge, which gives this Court the ability to review his decision without any deference. The 2 issues, the first is appellate counsel failing to raise an issue regarding trial counsel being prevented from eliciting testimony at the heart of the alleged victim's monetary motive to lie. And the second issue is ineffective assistance and a failure to request a DGM Batista instruction and to do additional investigation with respect to that instruction. And so starting with the first issue, the testimony at the heart of the alleged victim's monetary motive to lie was there was an attempt to elicit it with the question, and your belief is a conviction in this case will assist you in your civil suit. And the judge sustained an objection to that question. And that is—
I'll ask you a threshold question. You say that appellate counsel did not make a strategic decision to not raise this issue on appeal.
Correct.
And you rely on her affidavit. But that affidavit seems to me to be directly contradictory to the letter that she wrote in 2009, where she lists the issues that she considered and decided not to include, which included this particular argument. So how is that not a strategic decision?
Well, the appellate counsel did then submit a supplementary affidavit, which is in the record at Record Appendix 286 to 287, in which she explains that it was not a strategic decision because she was mistaken about the merits of the issue, because she had not—
But that doesn't mean it's not strategic. She might have been wrong, but it's still strategic, right? I mean, she considered making the argument in her brief and decided not to, so how is that not strategic? Aren't we under manifestly unreasonable review?
I guess I would draw an analogy to the line of cases that talks about limitations on investigation being reasonable only to the extent that reasonable professional judgments counsel in favor of limiting the investigation. Here, appellate counsel limited her investigation by failing to look at the record closely enough to ascertain how well preserved the issue was, failing to look at the cases closely enough to realize how strong an issue it was. And I think even if we are under the manifestly unreasonable standard, I would stand by my argument that nonetheless it falls short of the standard in Seoul, because it was clearly more likely to result in reversal than the other issues that appellate counsel raised. So I draw a distinction between a strategic decision made after a careful appraisal of the record and the relevant cases on the one hand, as compared to what we have here, which is an appellate counsel candidly conceding that she hadn't looked at the record closely enough and really hadn't considered the issue carefully enough to make a sound strategic judgment one way or the other.
Would you agree that counsel's opinion of her own performance after the fact is not determinative? In other words, it's up to a court to actually look at the whole record and decide whether or not counsel erred or counsel made a strategic decision. Would you agree with that?
Yes, Justice Hodgins, but I do believe that the affidavits from appellate counsel do deserve significant weight in that she knows best what was going through her mind at the time. And I do acknowledge that they are not controlling or determinative, but still, I would argue that they deserve significant weight, especially here where it was such a strong issue, because it wasn't...
Can I stop you there, because you anticipated my question. On a practical level, what more could the trial lawyer have extracted on this issue?
Certainly. So I think at the heart of it was the alleged victim's belief that a conviction in this suit would help her in the civil suit. That was the verbatim question that he had asked and that he was not allowed to get an answer to. And also being able to develop that although the civil suit was going to be against the the building manager, nonetheless, the allegations against the defendant would have factored very heavily in that suit, and that a criminal conviction would...
Didn't the attorney argue that? Don't we give the jurors at least a little credit for being able to draw that connection? It's not exactly a monumental extrapolation.
I guess it's tough because there were only 3 questions allowed. Have you talked to a lawyer? Is it about a suit? And it's a suit against a different defendant. And that did allow the Commonwealth to argue in closing that the suit was nothing more than a distraction. And I'd point the court to both the Elliott case and the Kowalski case. In Elliott, the defense was foreclosed entirely from asking about the related suit, but still tried to make that bias-oriented argument in closing. Similarly, in Kowalski, there was limitations placed on the, only partial limitations placed on the defendant's ability to cross-examine the alleged victim regarding her fear of her boyfriend from prior beatings. There was an argument in closing, as there was here, in an attempt to try and make something of that theory of defense, but because there wasn't sufficient factual grist to support that argument, still it was sufficiently prejudicial to require relief. And so I think trial counsel did the best he could under the circumstances.
Well, what was the limitation here other than sustaining the objection to the question about the victim's belief? What other limitations did the judge place?
Certainly. So in trial counsel's first attempt to elicit testimony regarding the alleged victim having met with an attorney, he was completely foreclosed from doing it. He then made an offer of proof to the court, citing case law, and the limitation was very strict. He said you're allowed 3 questions and only those 3 questions. Did she consult a lawyer? Was it about a civil suit? And was it against a different defendant? And I think at the very end of the redirect by the prosecution's last question was it against a different defendant? So really what the jury were left with was the strong impression that the defendant was trying to enact a distraction by bringing up some different civil suit against some different defendant. The jury wouldn't have known that it was the building manager necessarily. And certainly it requires a higher degree of sophistication to understand that even though the suit's against the building manager, still, as was the case in the Whitaker case, 418 Mass 196, the details of the alleged sexual assault factor very prominently because they are a highly relevant factor in whether or not the alleged assault was reasonably foreseeable from the perspective of the building manager or the landlord.
But, I mean, you always run a risk on cross-examination that the testimony might not come out the way you hoped as the lawyer doing the cross-examination. And you also run the risk that a judge can limit the scope of that examination. There's quite a bit of discretion in a trial judge, so you might not be able to present the story 100% as you wish. I mean, isn't that true in every case?
It is, Your Honor. I think that risk exists, and the 4 cases I would bring to the court's attention there were partial limitations on bias-oriented cross-examination resulted in reversal. There was Morin, where it was partial limitations around a tumultuous relationship. Stockhammer, partial limitations around the alleged victim's fears of her family and friends' reaction to finding out she'd had sex with the defendant. Kowalski, I went over before, about the alleged victim's fear from prior beatings. And the one that was right on point and that's not addressed by the Commonwealth is this Rhode Island case, Tiernan, which I think is persuasive authority that the partial limitations around the lawsuit that don't allow the defense counsel to make that connection. This is a lawsuit that would center on what this defendant did, and this alleged victim believes a conviction in this suit will win her money in the civil suit. That's the essence of it, and that's what's missing from this record. Unless there's other questions on that issue, I would like to talk a little bit about the DGM Batista issue.
I did have one question. So since this is being raised in the context of ineffective assistance, we're essentially under substantial risk review. The Commonwealth's argument in closing seems to focus on the implausibility of the motive defense, in that the victim was not the one who even called the police, right? So as the Commonwealth argued in closing, she was observed running, screaming, and it's a security guard that calls the police. And then a year and a half later, she meets with a law firm for the first time about a potential suit against the building management. So isn't the motive defense pretty weak here? It would have had to have been some sort of ruse from the beginning. Do you understand what I'm asking?
I do, but the question is not what the victim's motive was in running screaming from the building and getting the attention of the security guard. The question is, what was the victim's motive on the witness stand to try and play up the allegations in a manner that would result in a conviction, bolstering her chances of getting a monetary recovery. And I would draw a distinction between this case, because there was, and what was missing from this case, and other cases where there was held to be no substantial risk of a miscarriage of justice. For example, in Di Pasquale, there was testimony from a disinterested witness about what had happened. Here it was just a credibility contest between the alleged victim and the defendant's statements during interrogation. There was no confession here, as there was in Basquiat. There was no DNA or other forensic evidence, as there was in Karlhauser. And so as a result, the evidence was not among that class of cases where it's overwhelming evidence, and it really may well have made a difference to the jury, would likely have made a difference to the jury to understand, the victim's testimony on the stand at trial was colored by her belief that getting a conviction in this case would result in her being able to win money. Unless there's other questions on that issue, I'll move on to the D.G. and Batista issue, and what I want to...
Jump in right with a question on that.
Please.
So, as I read your client's affidavit, he walked himself into the police station because he wanted to get his side out there, essentially. He has a brief conversation, and then he goes into an interrogation room. How does D.G. and Batista even apply? If he's not in custody at the time he purportedly makes those statements.
Certainly, and so when we read D.G. and Batista, 442 Mass 423 at page 425, what the SJC held there is that you're entitled to the instruction if it's custodial interrogation or an unrecorded interrogation conducted at a place of detention. So it need not be...
Right, so where's the interrogation? That's my question. According to him, where's the interrogation? He says, I'm here to give my side. Some officer says, oh yeah, they claim this, that, and the other thing. How is that an interrogation?
So two things on that, Your Honor. First, the allegation is that the police fed him the details of the alleged victim's allegations, and specifically that he had touched her vagina. And that, that I would say is right in line with Rhode Island versus Innis, that's the functional equivalent of asking the question. Well, you know what she said about you? She said you did X. That's just like asking the question. The second point I would make on that point, and just like in Innis, what wouldn't it be terrible if some kid found that gun? You know, it's not quite a question, but it's the functional equivalent. The second point I would make is on the Cologne case, where in the Cologne case, all that was unrecorded was the administration of the Miranda warnings. The administration of the Miranda warnings is in no way, shape, or form itself an interrogation. It's not asking any questions other than, do you understand these warnings? And still the SJC held there that it was error for trial counsel to fail to request the instruction. And I would point out that the motion judge, although you're not obligated to provide any deference to the motion judge, found that it was error for trial counsel not to request the D.G. and Batista instruction. And I think at the very least...
So let's accept it should have been given. The problem I'm having with this argument is you're taking a rule that seems to me to be designed for assessing voluntariness of confessions and of Miranda waivers and applying it to something different, right? I mean, so let's say that the instruction was given, the jury were told, you should consider his statements carefully. Well, how would that have made a difference? I mean,
Certainly.
It seems like what you want to argue is that defense counsel should have been able to refute the Commonwealth's argument that he knew the details of what happened because they were true, but defense counsel had no evidentiary basis to argue that. So it's hard for me to see how the instruction would have made any difference.
Well, respectfully, Justice Sin, I would disagree that there was a lack of an evidentiary basis on this record, because Detective Fulkerson's initial testimony when asked is, well, I might have given him the allegations at the beginning of the interview, and then the prosecution comes back and pointedly asks, Did you tell him the allegations before you started the recording? And you can picture that kind of leading question, how it would play out in a courtroom.
All right,
Oh, no, it wasn't
so
before the
then
recording.
maybe defense counsel should have made more of that testimony, but how would the instruction have changed anything?
Certainly. So during closing, with that instruction, defense counsel could well have said, and you did hear during the interrogation my client talk about the details of the alleged victim's allegations. And you may wonder, how did he know those? Well, you're going to hear an instruction from the judge that will explain to you when an interrogation is partially unrecorded, you must assess that interrogation with great caution and care. And you heard Detective Fulkerson's equivocal testimony that he wasn't sure whether or not he had given any information about the allegations before the recording started. And so that gives you reason to doubt the notion that he only could have known those allegations because he was the perpetrator. It may well have been, ladies and gentlemen, that he was fed those allegations, as that would be a savvy police tactic. What's more likely? That someone marches themselves into the police station to try to give their side of the story and then inadvertently divulges details that only the perpetrator might know, on the one hand, or on the other hand, that you have a savvy detective who, before pressing record, recites some of these details in the hopes that, and these hopes proved well-founded, the defendant would reiterate those allegations during the interrogation. And if I might just close with one more comment on the DGM Batista argument, is I think what really drives it home is the Commonwealth's argument during closing, how would he know that? This was not a case with overwhelming evidence, and that was really a strong point scored by the Commonwealth, and there was no counter for the defendant. The DGM Batista instruction would have allowed him some counter. Unless there's further questions, I'll rest on my briefs.
Okay.
Thank you, Your Honors.
Attorney Walsh.
Good morning. May it please the court. My name is Emily Walsh. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. The trial judge properly limited cross-examination of the victim regarding financial motive. The trial judge let in a little bit more, I would suggest, than my brother recited. The court ruled, this is on transcript 2, page 6, the court ruled that the defense was permitted to elicit from the victim that she is familiar with a law firm, that she is seeking to file a civil suit against the management company based on this incident. The defendant was not prejudiced by that ruling, his attorney's handling of cross-examination, or the decision not to raise this in the first appeal. The defense heavily emphasized this financial motive, this claimed financial motive, both on cross and in closing, in 3 different places. He states on page 20 to 21, she changes her story. Why? Well, I would suggest that 1/3 of scratch doesn't bring much in a civil suit these days. And then again, on page 43, why would she possibly want to exaggerate the duration and intensity of this ordeal that she went through and the extent and seriousness of her injuries? Could it be the civil suit for money damages? And then again, she says she didn't meet with an attorney until January 2004. If you want to presume he's innocent, wouldn't you, this regards the police investigation, wouldn't you want to check that out to see if maybe there's a motive to lie, any interest in the outcome, financial interest in exactly when that happened? The financial motive was a central part of the defense. The only limitation were those questions. It was argued extensively in closing, and a judge has broad discretion to determine the scope of cross-examination. Furthermore, I would suggest that the motion judge is entitled to deference and that it is not a de novo review.
Would you agree that the judge was a little rough on defense counsel on that first day where this issue came up, and he said something to the effect of, "Well, it's almost 4 o'clock. We're not going there." And then he reconsidered it the next day because counsel filed a motion specifically asking to probe that issue again, right? So
counsel very effectively brought forth a motion to consider, and the judge heard the motion, reconsidered the finding, and set forth essentially 4 questions that the defense could ask the victim, which is a proper limit on cross-examination, and there was no limitation on closing. It was handled properly, the motion judge made the right decision, and that decision is entitled to deference. But even if it were de novo review, which it is not.
Why is it not de novo?
I looked for a 2023 case for that proposition, since there was some discussion about what the most recent holding is. In Commonwealth versus Fernandez, that's 492 Mass 469 at 474 through 75, the SJC states, in analyzing the defendant's motion for a new trial, where the motion judge neither presided at trial nor held an evidentiary hearing, we examine his conclusion only to determine whether there was a significant error of law or abuse of discretion, although, as he did not assess the credibility of any witnesses, we regard ourselves in as good a position as the motion judge to assess the trial record. So as though...
De novo?
I would suggest that de novo is different. Just because you're in as good a position as the trial judge does not mean that you need to consider it de novo. You can be in that position and still give deference to the motion judge.
So do I understand what you're saying, which frankly makes some sense to me, is that we shouldn't be looking at the affidavits and making credibility determinations?
Correct.
We should be determining whether the judge
Abused
made
his-
that determination, either made an error of law or abused his discretion.
Correct.
Okay.
Are there any further questions on the cross-examination issue?
Do you agree it was proper for defense counsel to ask the question about the victim's belief, and the victim should have been able to answer?
It wasn't
allowed to answer
necessarily
it?
that question standing alone is improper. The issue is that this was litigated before, there was a motion to reconsider, and the judge allowed for specific questions to
Right,
place
and-
a limitation on...
And that's the issue, right? So he says you can ask these 3 questions, but what was improper about, there was nothing improper about the question. Why shouldn't he have been allowed to ask that?
Because the trial judge ruled, you're going to be able to probe the financial motive through these 4 questions. And that's it. And then the defense attorney asked some of the questions. He did not ask his line of questioning. It's on page 23 of my brief. He said, so prior to your testimony today, you had the intention of filing a civil suit? Yes. And your intention is to file a civil suit after this? Yes. He did not explicitly ask against the management company based on this incident. He was given permission to ask those 2 questions, and he didn't. And instead, he says, is your belief that a conviction in this case will assist you in the civil suit? Which is beyond the scope of what the judge had limited the cross-examination.
Right, and the question is whether it was a reasonable limitation, and I'm asking,
Yes.
why was it reasonable to sustain the objection to that question?
Because she had placed a reasonable limit on cross-examination, and he went outside the scope of it by asking
Why was that
question.
reasonable, is what I'm asking.
Because it gets across the financial motive of the victim, the possible financial limitation. The questions were narrowly framed by the judge, what he was allowed to ask, and instead of asking those questions that he had approved, he asked other questions. The judge has wide discretion to determine the scope and extent of cross-examination, and he went afield of that, and so the objection was sustained. And that is reasonable.
All right.
If there are no further questions, I'll move on to the DGM Batista instruction. The DGM Batista instruction, the lack of DGM Batista instruction in this case does not give rise to a substantial risk of a miscarriage of justice. The only evidence in the record that any officer told the defendant the specifics of the allegations prior to the recorded interview are the affidavits from the defendant and his wife. The wife's supplemental affidavit states that she was in the interview room and that she heard an officer in that room say the specifics of the allegations. Her appearance is not reflected in the appearances list on the transcript, and it is inconsistent with the defendant's affidavit.
Let me just ask you about that. Why would that matter? I was puzzled by that. If a transcript has been made of the interview with the defendant, and the only people in the interview room are the officers and the defendant,
Yes.
why would there be any suggestion that someone who was outside the interview room,
The wife
their name
claimed-
should also be on it?
The wife's affidavit claims she was in the interview room, which is in conflict with all the other evidence, and is part of why the motion judge discredited her affidavit.
I see what you're saying.
So
Okay.
the defendant's affidavit essentially says, I came down to the station to find out exactly what was going on, just to make sure, which is essentially him coming into the police department and saying, what's going on? The defendant initiated the questioning. it's inferable that that was like a desk clerk or something, because he basically came down to the police department and said, I want to clear this up, what's going on? So the defendant's affidavit says that he had this conversation and then he was brought into an interview room. The wife's affidavit says, we were all in the interview room together and they said this to him. So the only evidence that these allegations were ever shared prior to the interview are from two conflicting affidavits between the defendant and his wife. Further, trial counsel's affidavit does not corroborate the defendant's claim that he was told about the details of the incident prior to the interview. Current counsel specifically asked Attorney Tuig to address whether the defendant ever told him that police had described the details of the victim's allegations before they began recording. Trial counsel declined to corroborate and stated, prior to trial, I was aware there was some discussion with the police because the Miranda warnings were not recorded. I remember asking and discussing with the defendant everything that was said from the time he began speaking with the police to the time he learned that he was being charged. I am now aware that the defendant says there was much more content discussed with the police. Essentially, he says, he didn't tell me. So even if the defendant were able to show that these details were given to him, the question is not whether the allegations were actually given or whether they should be recorded, but whether the defendant told his trial counsel about the interaction and counsel was ineffective in handling that. And trial counsel's affidavit does not establish that those details were ever shared. Counsel was not ineffective, and the lack of DG and Batista instruction does not give rise to a substantial risk of a miscarriage of justice.
Do you think your stronger argument is not a credible suggestion that the information was actually given, or the Batista doesn't even apply because even by the defendant's own affidavit, he wasn't in custody, nor was he interrogated?
They're equally strong in my view. I mean, there's really almost no evidence that that these details were ever shared, and DG and Batista simply does not apply here. DG and Batista it's a situation where officers ask a suspect questions that are reasonably likely to elicit an incriminating response, and then the prosecution introduces evidence of a confession or statement from the defendant. In this case, the statements the defendant now claims were made and should have been recorded were not the product of interrogation. They were a defendant's question, and they were not made by the defendant. It was not a defendant's confession. They were statements made by another officer, purportedly made by an officer prior to a custodial interrogation. If there are no further questions from the panel, thank you.
Thank you, counsel. The case is submitted. Next case is Commonwealth versus Cedric Williams, number 2023 P192.
Good morning, Your Honors. David Bradley on behalf of the Commonwealth. May it please the Court. I would ask you to remand this case back to the Superior Court and ask that the Court make further findings with regards to the length of delay. Judge Ullman decided this case. It basically stopped saying that there was no justification to hold that phone for the 34 days. But there was probable cause to seize the phone. Judge Ullman.
Can I ask you just another question about this? What struck me is, and you can ask Spurlock the same, what impact from your perspective does the defendant's failure to ask for his phone or a phone back, because in his affidavit he doesn't even claim it to be his phone, understandably. What impact does that have on this?
There is a United States case called United States v. Stable. It's a Supreme Court case. It's United States v. John. It's 469 U.S. 478. The defendant who never sought to return the property cannot argue that the delay adversely affected the Fourth Amendment rights. So there are
How was he able to? Because normally what happens in these cases, right, is the defendant's charged. So his lawyer walks into court and files a motion to return a property, and the judge probably says, okay, what are you doing? You're getting a search warrant. And they say, well, we're thinking about it, and they say, okay, you got about a week. Either get the warrant or the phone's going back, right? Didn't have that here, so it makes it a little bit more difficult to analyze, it seems.
Sure. I would just ask that Your Honors take consideration this aspect of it. The officers responded to a shots fired call. They were responded relatively quickly, within a minutes. They were on scene. As they made it their way to the back of 196 Blue Hill Ave, there were two males there. They heard two males arguing over a firearm. When they approached the defendant and the other gentleman, those two gentlemen immediately turned away from them. They pat-frisked them for their safety. This was a high-crime area. This was an area where there was drugs and prostitution. And they pat-frisked them, didn't find anything, and let them go, and the defendant was milling around the area there. Then a woman identified herself to the police officers and said, that gentleman right there threw a firearm. And almost simultaneously, the officers then found the victim on the third floor suffering from gunshot wounds. The defendant said, my best friend had been shot. My best friend had been shot, giving him the knowledge that somebody had been shot. And where she had indicated that he had thrown a firearm, there was a firearm there found by the police. In between the time that he was pat-frisked and found no weapons on him and the 2 minutes approximately that he was then taken into custody after they found the firearm, the defendant was seen using his phone at the scene, communicating through his phone. He was then transferred to headquarters, and then at headquarters, he was interviewed at headquarters and made some quite inculpatory statements with regards to the use of his phone. And there were two phones recovered
He made
from
what?
him.
Inculpatory statements?
So he said that I was called to the scene from somebody that he refused to identify, that he said that his best friend had been shot, that he had communications in the car, and that he did not or refused to identify those people that were there on scene to the police officers. So you take that information and you couple it with the fact that he was using the phone at the scene. He also admitted that he was a drug dealer, and I would refer your honors to
How do we consider those statements when they were made after the phone was taken?
So there are two timings here. One is the seizure of the phone itself on scene, and he was placed under arrest for all intents and purposes on scene because of the firearm and transported. I would suggest to your honors that the moment that he was seized and that phone was taken from him, they had probable cause to seize that phone as a piece of evidence as
He was using it in the
based
aftermath
upon
of the crime?
Correct, that he knew that there was somebody shot, that he had tossed a firearm.
All right, let's assume that that's correct.
Sure.
All right? They seize it based on probable cause.
Yes.
This is analogous to securing premises, right? Like you secure someone's home
Sure.
because you have probable cause, but you don't search the home, and then you go and you get a warrant to go inside the home and search.
Yes.
With that as the analogy, do you think waiting 34 days to get a warrant to search a home is reasonable? Can the police hold on to that home for 34 days?
I think the Judge Ullman decided correctly that that phone was properly seized. The next question is how long can you hold on to it for? And I take your question. But it has to be placed in the context of the information that they then learned at the police station before they let the defendant leave and before they actually held on to that phone. And that, coupled with the proper seizure of the phone, that was going to be a piece of evidence. While they were interviewing the defendant, he was saying that he asked for my iPhone back. The police had known that they had taken two phones off of him. They took the cool pad off of him at the time that he was arrested on scene. And during the time that he was transported from the scene back to the headquarters, they took another phone off of him, which was an iPhone, a red iPhone. They placed it on the desk. That phone was ringing. The victim's property was ringing at the same time, or making sounds like that. The detectives opened up the victim's property, and he had been a victim at that point. He had deceased. The iPhone watch from the victim's property was matching up and syncing up with the phone that was taken off the defendant. And so you have more information now. The fact that there were two phones on the defendant, the fact that he said he had a burner phone because he's a drug dealer, or there's a reasonable inference to say, he said, you know what I do, I have another phone, that he made communications with that phone. That phone was going to be a piece of evidence because it shows a consciousness of guilt when we try this case to show that he had another phone, but he wanted the victim's phone back. It was more important to him because of the fact.
Let's say that you're right on that, okay? Let's assume you're right on that he was actively misleading the police during the interrogation and suggesting that the other phone was actually his phone, and he wasn't saying anything about his phone. let's assume that that's all true. Are you suggesting that that misleading then gives the police 34 days to get a warrant?
Yes, because he lost his possessory interest in that phone at that point, because that was now a piece of evidence. We're going to hold on to that.
They don't log
case.
it as evidence, they don't put it in his inventory, do they?
They don't log it as evidence, but I would suggest that that's not necessarily dispositive of whether or not they hold on to it. They have it, they put it on in my
I
practice.
take it as property. I mean, you usually fill out the little property form, they didn't do that either.
Sure, that's when somebody's arrested.
Right.
And
I
there
guess
was
he
no-
wasn't, right.
They
Fair
seized his clothing, and they seized, they took swabs of his gunshot residue. And going back to your question, and this answers, I think, your question, I hope at least, that's my job, right? But this is not analogous, with all due respect, Judge Hodgkins, to the apartment. An apartment or a car is something tangible that somebody, you can only seize it for so long because that's somebody's house, that's somebody's car, that's movable, tangible, somebody uses that. This is different. This is a cell phone. This cell phone information is just stored there. We're temporarily holding it onto it. And as a piece of evidence that's going to be used at trial, the contents of that phone, doesn't matter whether or not that contents of phone is searched at the time, that phone is still a piece of evidence. And then they applied for a warrant on addition to that. It doesn't matter if it's 34 days, 180 days, 1,000 days, that piece of phone is never going back to the defendant. He has no possessory interest, again, into that phone until the trial's done, because it is a piece of evidence. It's analogous to taking the gun and asking the gun back. That gun's not coming back to him. That gun's going to be part of the evidence at trial. The delay.
So, excuse
It's
me, so
reasonable,
your position is if the police get the warrant, search the phone, and find nothing of evidentiary value, they still get to keep the phone until trial?
Yes. There's two separate things. There's the physical, it's almost like a backpack. You seize the backpack, and there's contents in the backpack. You get to seize the backpack. If it's a red backpack and say the witness said that there was a red backpack, the red backpack is still going to be a piece of evidence. What's inside the evidence, the digital evidence, may or may not if we don't have probable cause for a warrant. But in this case, we absolutely had probable cause for a warrant in this case.
Yeah, but see, the problem with that is, this is from the Onyx White case. Police may retain an item seized without a warrant for the relatively short period of time needed to obtain a search warrant, but must release the item if a warrant is not obtained within that period. And then the court, the SJC, cites to Commonwealth v. Gentili and Commonwealth v. Taylor. And what's interesting about this citation is both Gentili and Taylor refer to the very same analogy that I referred to with searching a home, that you can't, you can secure premises for the same reason for a relatively short period of time needed to obtain a warrant. But you can't just secure the home for 34 days and then get the warrant. The expectation, as the SJC tells us, is that there will be diligent work by the police to present a warrant application to the judicial officer at the earliest reasonable time.
I agree with that reasoning in Onyx White, but that is factually different than what we have in this case. Onyx White, the phone was seized on essentially a hunch by the police officers. That was a young man whose phone was taken at the school.
Or was it a hunch or was it probable cause?
They had the SJC has decided that it's a hunch at the time that the officers thought it was probable
Okay, all right,
cause.
you're talking about that case. Okay.
No, but the distinction really is important here because this case is much more analogous to Arthur, which the defendant cited in his brief, which is 94 Mass 161. In Onyx White, the phone was in somebody's third-party possession. The detectives in that case essentially said, look, there's a crime, it's been involving multiple people, this person has a cell phone. It would be common sense, essentially, that the phone has got to have information with communication. They went and seized the phone, and there was no analysis there of whether or not they had any information that phone was used in
Well,
communicating
they eventually
with their
obtained a
person.
warrant to search the phone, right?
Correct.
So it's the same situation here.
It is not the same, respectfully, Your Honor, because we had probable cause to seize that phone in this case. In Onyx White, there was no probable cause to seize the phone. That was In this particular case, that's what the SJC decided. And in this particular case, Judge Ullman found that there was probable cause to seize the phone. Then the phone is then...
He didn't find that. He did not answer that question.
He
He actually expressed doubt that there was probable cause to seize the phone. So if I understand you correctly, you're saying if it's determined after the fact that there was probable cause to seize an item of property, the police can just hold on to it indefinitely before they seek a warrant, and there's no problem with that?
If it falls within the category of a piece of evidence that's going to be held for trial anyway, the person loses their Fourth Amendment rights to the possession of that instrument. And that's what we have here. That phone is going to be used as a piece of evidence anyway, and that's the
See, I think
essentially the
this
facts
is where
of
your
life.
argument runs into trouble, I think, because if you had probable cause to seize that phone, why is it so difficult to then go back to the police department and put pen to paper and write up an application for a search warrant based on that probable cause?
Judge Ullman actually didn't decide that issue of whether there was reasonableness of the delay of 34 days. He found it just per se unreasonable without looking into the details of that delay. And I can get into that if you like. The delay in this particular case, the officer seized the phone. They did an investigation. They started a grand jury. They identified the eventual co-defendant in the case. They went down to Georgia. They met. They had several days of a grand jury investigation. They ordered the CDR records to confirm the fact that the phone was actually used at the time. They found that the phone was being used at the time, and that then they were able to then write a search warrant on that. There was fairly diligent within their time frame, and they were doing things that were diligent about the investigation. It wasn't just that they were holding it. They could have written a warrant that night, but they didn't. They were taking extra steps because you're asking somebody to go into somebody's phone, as the court in Riley and all of the other cases that come from that. It is a personal thing. You're going into somebody's personal thoughts. They were pragmatic and thoughtful and cautious and make sure before. But they also had other obligations through the investigation as well. And if that phone is going to be a piece of evidence, then...
Can you address that one more time? Maybe I missed
Sure.
it. What, independent of its digital contents, gave that phone evidentiary value?
Because he's lying to police about the fact that it's his phone. He's saying that the iPhone is his phone. He wants the iPhone back. In I think it's page 13 or 14 in his transcript. He's saying, I want my iPhone back. He doesn't say anything about the cool pad. He says, that's a phone that, I'm a drug dealer, that's what I do. You know the deal, basically, on the phone.
He's saying that's not my phone, and they want to have the phone to say this is the phone that he says is not his phone.
Correct. And
regardless of what's inside it.
Correct. He's saying I can open that iPhone with my fingerprint, thumbprint, and that's the detectives at the time knew that was a lie because it was the victim's phone. He may or may not have been released. He doesn't. And in fact, the detective in his interview say, we're not arresting you. We're talking with you. He wants that phone back because that phone is going to directly link him to the murder of the victim because it's the victim's phone. And that means that the other phone on him shows that he's lying about the iPhone.
Okay, your time is up. Let me just check to see if there... Okay, thank you, Counsel.
Thank you very much, Your Honors. Appreciate it.
Attorney
May it please the
Spurlock.
court, Matt Spurlock for Mr. Williams. The Commonwealth fundamentally misunderstands the law here. Probable cause is merely a threshold requirement to seize a container, to seize property without a warrant. Even with probable cause, which Justice Shin is absolutely correct, there is actually no finding on that. Judge Ullman found it questionable, but didn't reach a case it didn't need to. Even with probable cause, police still have an obligation under Article 14 when they seize a container without a warrant to diligently work to make it a priority to present a warrant to a neutral magistrate at the earliest reasonable time. The SJC has described that time as a relatively short period of time necessary to get a warrant.
Mr. Spurlock, as I promised I would, I'm going to ask the same question of you, which is, what obligation do the police have affirmatively to seek out, in this case, your client, to return his phone?
So I think
let's say it was a backpack, or let's say it was his toothbrush.
there's no question here that the phone belonged to my client. It was seized from his person, right? So
Right.
White answers that question completely. This was seized. He has much stronger property interest.
But in White, they asked for the phone back.
No,
No?
in White, there's nothing in the record about asking the phone back. In White, they took it from his school, right? They took it from his school.
Okay.
There's no obligation to ask your property back. The police seized it from him, from his person. He tells the officers the phone number of the phone. His face is on the screensaver of the phone. This is all in the affidavit, and it's in the record. And, contrary to what opposing counsel has represented, there's no denial in the interview that this phone was his, even if that were somehow relevant, and it's not. So there's no question that the phone is his. His affidavit in support of the motion to suppress.
Well, it wasn't so much a denial, it was more that he was claiming the other phone was his and pretty much ignoring his own phone.
Sure, you can have
right?
more than two phones, and he acknowledged that. So if you watch the video, he goes into his pocket to look for his phone, which has been seized from him. So but that's all irrelevant. There's no question under any
But isn't it important though? Because that could be construed as he's misleading the police, and that might delay their ability to seek a warrant now, because now they're wondering, well, whose phone is this?
Well, if you were misleading the police, that might be a question that they could put in the warrant application. I don't think that's even presented in this case. But let's assume, again, probable cause. Let's assume, I don't believe that's a fair construction of the record, that he was somehow misleading the police. There's certainly no findings on that below because it wasn't ever raised. But that's still just something you put in the warrant application to a neutral magistrate at the earliest reasonable time, right?
What would you say would be the earliest reasonable time here, given the circumstances?
A couple days at most. If they have probable cause, which again, Detective Mills thinks he doesn't have probable cause, right? So that's, part of the perversity of what happened here is that you have a detective says, I don't think I can write a warrant right now. He misunderstands the law. He thinks that he can hold the phone without probable cause and continue investigating until he musters enough probable cause to put that before a judge, and that's just not the law.
So from your perspective, is the obligation of the police to call him and say, please come and get your phone? Is it their obligation to drive and try and find him and drop the phone off at his house? Are they supposed to put it? Where does their obligation begin and end in terms of initiating the return?
Well, I don't think, Your Honor, I don't think any of those questions are really presented in this case, and the court, wasn't discussed below, and I'm not really prepared to, go into hypotheticals like that, but I do know that there's simply, under any of the case law, no question that my client has a possessory interest in here, much stronger than White, much stronger than any of the federal cases that are cited. I'd like to talk about Arthur for a second, because the Commonwealth claims that this is a case that is closer to Arthur, and that somehow because the cell phones were in themselves evidence, they could be held without a warrant. And that's just wrong. That's just wrong on the law, right? This is not a gun. This is not drugs, right? This is a container that, as Riley teaches and all of the phones about cell phones teaches, is really a mini computer that holds a library, that holds our photos, all sorts of important things. So that's just not right. It's not per se contraband. And the second thing is, in White, the relevant number is 3 days. The police there, under the theory that the cell phones were independently evidence, as the cell phone themselves in that case, went and got a warrant to hold that independent evidence 3 days later. And Judge Englander found that was the crucial distinction between White. They got a warrant after 3 days, and, between Arthur, they got a warrant after 3 days, and White, right? That's the distinction. So that it's true that a couple months later, they went and got a warrant for a more invasive search. And that was just good police work. And during that time, between the 3 days and the 85 days, the defendant in Arthur had no interest in the phone, right? His interests were incredibly reduced because he was never going to get the phone back. But that was only because some neutral magistrate had decided after 3 days that the police were justified in holding the phone, and they had a constitutional justification to do that. Now, the rule that the Commonwealth seeks would just allow them to blow right by that and hold the phones for however long they wanted while they develop probable cause. And I don't deny that there was a diligent investigation in this case afterwards. The problem is that, as White teaches, it's right there in White, it's not the general diligence of the officers in pursuing this particular investigation, it's the diligence with putting a warrant application before a neutral magistrate. That's the relevant diligence.
Is there anything to the argument that, at least as I read the affidavit in support of the motion to suppress, the defendant didn't actually claim the phone was his? And so, unless is there automatic standing here? How does he, if he's saying it was a phone that was taken from my possession, but
There's no
my phone for, I mean, and he doesn't really have a standing to challenge a search of my phone, if he happened to be holding it.
Your Honor, I don't think there's any question about standing here. I would say even in Cruzado, right, which was a case where the defendant had the phone for 1 day, claimed that it was given to him by somebody who couldn't remember, it had a different screenshot, all those things, even there the SJC said there was standing. And this is, I mean, he just has so many more possessory interests than in White and in Cruzado.
But see, okay, but standing, that's just one
Sure.
issue. But related to that is the possessory interest. And that's what's supposed to be weighed here, right?
Yes.
And Judge Ullman refers to that. He refers to the balancing on page 8 of his opinion at 70 of the appendix. The nature and quality of the intrusion on the individual's Fourth Amendment interests against the importance of the governmental interests alleged to justify the intrusion. That's what's supposed to be balanced. So the possessory interest that the defendant has on the phone is vitally important.
Agreed.
And yet, I've read this opinion many times, and I don't see the judge ever going back to that and actually making that balance. So he refers to the need to balance, but I didn't see that in there where he actually does that balancing.
Your Honor, I think that it's simply, there's no question that his possessory interests are strong, robust, and undiminished. They're the same and much stronger than in White. And by referencing that case White, I think that's all incorporated there. The important thing is what are the government's interests in delay? I cite a number of federal cases in my brief that discuss this in more detail, and every time that those cases show some diminished possessory interest, we're talking mostly about hard drives where they were seized with consent sometimes, and also that the defendant in those cases had the ability to download things and the ability to use some of that data. So there are some situations where you could have a somewhat reduced possessory interest. The other situation is a situation like Arthur, where the police have an independent reason to hold it, based on a separate warrant, right? And that's what they could have done here and what they should have done here. They should have, at the earliest reasonable time, which SEC said is a short period of time, sought some warrant with whatever probable cause they had from a neutral judge, and then 34 days later, when they've done this other investigation, they could have got another warrant for more intrusive, more precise information from the phone. That's what's supposed to happen under the Constitution, and that's what White teaches, that's what Arthur teaches, that's what all the federal cases teach as well. The notion that the police can seize property with or without probable cause, but without a warrant, and then wait while they develop probable cause.
But let me just go back to my question, though. And if it's in here, please point it out to me. Did the judge undertake that balancing that you're discussing now?
There's no discussion in that page-long part of his order discussing independently why a person has an important interest in their cell phone, and that is just common sense, and it wasn't really challenged below. I mean, it's black letter law at this point that defendants have strong possessory interest in their cell phone, and White, the citation to White suffices, I think, to cover that concern. The question then becomes, what were the Commonwealth's interests in delay? And that was really the only open question on that issue.
Yeah, but just having a cell phone, that's not enough, because in the Cruzado case, the defendant had the phone, but he had it only like for a day, right?
So that case is quite different, right? Here we have a phone that was seized from the defendant. It was a phone that his phone number works on, which is right in the affidavit, a phone number that has his face on it. And so there's really, it's
But I'm talking at the time the phone was seized, though, right? What do the police know at that point?
Well, at some point during the 34 days, they find out that the phone number that he gave the police on that, so he told the police his phone number, right? So the notion that he's lying, during the interview, he tells them his phone number. He gives them the phone number that rings to the phone that we're talking about today. So, if a defendant says, you take the phone from him and then he tells you his phone number, and you later open it, you call it, and that rings, you later open it, and it's his face on it, it's pretty clear, it's quite distinguishable from Cruzado, and it's much better. His interests are much stronger than interests in White, where you have pay-per-go phone seized from a high school student that had been confiscated by his high school, right? So these interests, it simply wasn't really a question because it was so clear that the phone was his and that he had a possessory interest in it.
So are you saying that we should undertake the balancing that the judge didn't undertake?
I think he undertook the balancing. I think that this common ground that defendants and citizens have strong interest in cell phones that they use, and I think it was unquestioned and uncontested that he had the cell phone on him. Now, the question that Justice Brennan posed, whether you have an obligation to perhaps under Rule 61 or something like that, seek return of your property, that has never been the law. And, White would have said something about that if that was the case. I think it would be especially perverse to impose that sort of obligation here where, the defendant here, Sir Williams, was unrepresented for the entire duration of that 34-day delay. In fact, not charged. So he had no one, there was no case that he could have even filed a Rule 61, motion in. And, so the rule that the Commonwealth would seek would then allow the police to, grab things from people based on whatever probable cause they thought they had at the time, not reviewable by any judge, and then hold it while they develop probable cause. That's the rule that, co-counsel was advocating for today. And that's just not the case.
The iPhone was determined to be the victim's phone, right?
After the fact, it appears from what's in the affidavit that it may belong to the victim. And that's not at issue today in this interlocutory appeal. It's a very narrow issue in this interlocutory appeal, and Judge Ullman's memorandum of decision is quite sensitive to all of the different issues here. Are there any further questions? Okay, thank you very much.
Thank you, counsel. The case is submitted. One minute while we check on the microphone. You can come up, counsel. All right, the next case is Commonwealth versus Miguel C. Fletcher, case number 2022 P687. Attorney Studler.
Yes, Your Honor. May it please the court, Carl Studler for Miguel Fletcher. Your Honors, the lower court erred in this matter and abused its discretion when it denied Mr. Fletcher's post-conviction motion for expert funds for a vehicle speed expert. This was a case where the explicit basis of the trial judge's verdict for finding that the defendant operated negligently was only his speed. The trial judge said that he found that he was traveling 50 to 60 miles through the thickly settled Central Square area. And as set forth in the record, present counsel consulted with an expert accident reconstructionist who was willing to give a preliminary consult, who conveyed that it may not have been possible for Mr. Fletcher's bobtail tractor to be traveling that fast and still make successfully the left-hand turn without swerving or even leaving his lane as the record established.
Mr. Officer, you don't think that was a little vague at all? To say, well, hey, have an expert, maybe an expert who might say this about what could happen or have happened or not have happened. For the judge, I mean, the judge has pretty broad discretion here, right? And the judge has to go through an analytical process with a private person paying out of their own pocket, pay for that sort of an expert in this particular case.
Thank you, Your Honor. Your Honor, it was, I think, necessarily vague at that stage because the expert needed to do specific calculations in order to determine whether his his opinion that that very well might be the case, whether, in order to know that for sure, he would need to be able to do further calculations, which included taking measurements of the turn area, the dimensions of Mr. Fletcher's tractor, and then being able to plug in at different speeds how fast, what's the maximum possible speed that the tractor could have been traveling in order to safely make this turn as it did. And that's something that it was set forth what he would need to do and how long he expected to take and what he would charge for it. So it was set forth in significant factual detail.
Right, but I mean, I think the issue is that the standard is the defendant has to make specific and not speculative allegations that's going to uncover evidence that will materially aid him, right? So an affidavit says that the expert might conclude this seems to me to be insufficient.
Thank you, Your Honor. Your Honor, in this case, I do not believe it was insufficient because the standard for post-conviction discovery is that if the facts are fully developed, the petitioner may be able to demonstrate he's entitled to relief. And so we had an expert and a path for fully developing those facts laid out on the record, and the trial court denied it. The motion judge denied the motion based on criteria that fell outside the relevant standards of law. In particular, he said, required an affidavit. He said the motion judge said that the motion was denied because there was no affidavit from the expert himself, and that is not a requirement found in the rules of criminal procedure. And then after President Counsel talked to the expert's office again, I wasn't able, as set forth in the record, they weren't willing to do any further work on spec without guarantee of payment. That was put forth to in this case, the trial judge, who simply wrote denied on the motion without more. If Mr. Fletcher had funds, we wouldn't be in this situation if you could afford to retain it.
You mentioned the trial judge's findings, or if not findings, comments when he rendered his verdict. Is it your argument that our consideration of the evidence, when we analyze the sufficiency of the evidence, is limited by those comments?
Your Honor, no, Your Honor, I wouldn't say that it's
So when he says, well, I found him
limited.
guilty because he was speeding, and I know that intersection, and if you're going that fast in that place, you're negligent. That doesn't limit us. We can still consider any other evidence that was part of the record?
I think you can, Your Honor, because I think that's really where the focus and where the place that the trial judge talked about the defendant, what he found the defendant sped at, that's really the only place that could possibly qualify as a place where driving at that speed might endanger the safety, the lives or safety of the public. There's no other point in the record where there's that plus factor that's more than mere speed.
You weren't the trial attorney, were you?
No, Your Honor.
And so, just one more question, and that's with respect to strategy, and I think you argued there's no conceivable strategy as to why you would concede the speed, right?
Yes, Your Honor.
Anything at all to be said for a lawyer, an experienced trial lawyer, reading the room, looking at the judge, knowing how the judge might respond, sensing that if you at least give something on what might have been, at least on the record, uncontroverted, that you might have a more receptive audience than if you just deny everything and maybe the judge tunes out after the first 30 seconds of your closing?
I would say no, Your Honor, that in this case that it's trial counsel's job to defend both charges, and where there was no strategic linkage. It's not like Commonwealth v. Murphy, another case I cited, where the trial counsel allowed for the possibility of conviction on the lesser included of negligent operation when the client was charged with vehicular homicide.
Well, he says all we have is speed, and speed, as you know, Judge, is not enough. Speed alone is not enough. That seems like a pretty good strategy.
So, Your Honor, and based on the record, what came out at trial, it wasn't a good strategy because there was measurement or estimate, or even an estimate from an officer saying this is how fast the defendant was going. The only numeric measurement on the record was the officer saying, I was driving 60 miles an hour.
Wait a minute, but don't we, I mean, people make those estimates every day. I mean, I did it on the turnpike this morning. If I'm doing 65 and someone's driving past me, then I can pretty reasonably infer that they're driving faster than 65 miles per hour. Right?
That's correct, Your Honor. Your Honor.
Officer did in this case?
Your Honor's point is well taken. That's not what the officer did in this case because the defendant never passed him. The officer saw the defendant ahead of him, and he followed the defendant and caught up to the defendant. He never said on the record what his estimate of the defendant's speed was. He said that he himself in his cruiser traveled 60 miles an hour, which allowed him to catch up for the defendant. The record revealed that this was over it was estimated a 0.7 mile stretch, and on cross, the officer, or the sergeant, admitted that there was a time during his catching up with the tractor that he stopped at he had slowed down for a red light and then proceeded. So with only the officer saying how fast he got, all that establishes that the defendant must have been traveling less than 60 miles for him to catch up, and probably significantly less if the officer had to slow down for a red light during his pursuit. So we're really left.
I mean, you would agree that a person can observe if someone's speeding without taking out a radar and capturing a number, right? And in fact, the faster you're going, isn't it easier to observe that?
I'm not sure I understand Your Honor's point about
You're
faster.
saying that there's no evidence of speeding because they didn't take a numerical measurement, but a person can observe someone speeding. I mean, I know when someone's speeding without taking a measurement, right?
It could be possible to discern that, and I don't think in this matter there was an adequate basis in the record.
We observed him peeling out of the parking lot at a high rate of speed and going around the rotary and then taking off at a high rate of speed. It seems pretty clear to me they were saying he was speeding, and so when you're talking about trial counsel strategies, I mean, what was he supposed to do with that?
Thank you, Your Honor. Your Honor, trial counsel, it was available for him to point out the lack of any measurement of the defendant's speed as opposed to the officer's speed. That was available for him to do right on the record at that point. And I would also contend that for an officer to say a high rate of speed, that's a very subjective statement. They're not really putting out there a falsifiable statement like that if they were saying he was going over the limit, they could have estimated, he was going definitely over the limit, 10 miles over. But just a high rate of speed is so vague and subjective. I think it's not fair it's not sufficient in terms of the evidence to hold that someone went over the speed limit, and especially that they sped sufficiently over the speed limit in the time and place in question that it might endanger someone. It certainly doesn't establish.
If your argument is that there's no record evidence that your client was going 60 or 65 miles an hour, why doesn't that undercut your argument that you need an expert to say he wasn't going 60 or 65?
Thank you, Your Honor. Your Honor, it's because because that was the insinuation at trial, and that was what the prosecutors, that the defendant was traveling 60 miles an hour, and it was what the
There's no evidence. Don't we assume the judge figured that out and said, well, it wasn't 60 or 65, although we did say 50 or 60, so maybe not.
Thank you, Your Honor. Yes, as Your Honor points out, he did say 50 or 60 miles an hour. That figure wasn't in evidence with specific reference to the defendant's speed. It was in the prosecutor's closing argument, so it was insinuated that he must have been speeding, he must have been traveling that fast, but it wasn't established, there wasn't sufficient evidence to permit a fact finder to draw that conclusion.
So the best your expert would have been able to do if he came in, and this is a little speculation here because we really don't know based on his affidavit, but would be to say that at one point in time during this whole episode, when the truck was going around the rotary, that at that point he couldn't have been driving 60 miles an hour. right? Isn't that really the best he could have done?
Yes, Your Honor, you could have placed an upper limit on how fast he could have been driving. But that is, well, that's one point of time, basically the 3 points in time where there's alleged speeding. On the rotary was right before Main Street, so what the expert would set forth in terms of how fast he could have been going around the rotary would be relevant to how fast he could have been going shortly after on Main Street.
So it'd be limited.
It would be limited, but it would be relevant to the Main Street alleged speeding, but really the out of the parking lot, that there was not even a speed limit specified on that stretch of road, and it was simply stated that he took off. Again, no allegation of any negligent driving behavior other than saying he took off at a high rate of speed. So I think what was really at central issue in this case was the speeding through, alleged speeding through Central Square.
What about crashing into the car?
Thank you, Your Honor. Yes, that was, reviewing the record on that, the record evidence that he did so was extremely slim. He wasn't charged with leaving the scene of an accident involving property damage, and there was no witness that testified that his vehicle hit that vehicle. And in fact, there was exhibits on the record showing the slightly scuffed front bumper of that vehicle, but there was no prior photo for comparison. So, Your Honor, in this matter, there wasn't enough evidence to permit a finding that he damaged the GMC Safari that night, the vehicle, much less as a result of negligent driving, because the mere fact of an accident isn't enough to establish that he drove negligently, and here there wasn't even enough to establish that he was involved in the accident. Otherwise, they would have charged him with leaving the scene. So, hearing no further question, I will rest on my briefs. Thank you, Your Honors.
Attorney Palumbo?
Good morning, Your Honors. Karen Palumbo for the Commonwealth. May it please the Court. I'd like to address the issue of negligent operation. It's not only speeding in this case, and the speed at which the judge found the defendant was traveling is a reasonable inference based on all the evidence presented at trial. But there were other factors to consider here. The defendant wasn't driving a regular vehicle. He was driving a tractor-trailer extended cab, and it's a very large vehicle. When Sergeant McDermott pulled the vehicle over and stood at the driver's side, he said it was about 10 feet up to where the defendant was sitting, his head. So it's an extremely large vehicle that's speeding out of a parking lot, through a rotary, and down the road. There's also other evidence here. The defendant admitted that he had consumed 3 beers and a drink. He was thick-tongued and slurred speech. He had bloodshot and glassy eyes. And he made an unsolicited statement that I did not hit the vehicle. I would suggest the court looks to a number of factors in determining whether there's sufficient evidence for negligent operation, and those factors certainly meet that standard.
Well, would you agree there's not enough evidence that he was the one who actually hit the other vehicle?
Yes, and he did hit, that's evidence at trial, but I'm not saying that that's evidence or that goes to the negligent operation charge. There's sufficient evidence without any accusation or any evidence that he struck that vehicle. With respect to the defendant's post-trial motions, he provides no affidavits. It's abuse of discretion, and with merely speculative claim to the court, I would say the judge did not abuse his discretion in denying those motions.
Well, you'd agree, though, that, counsel makes a good point, that it's a little difficult after trial to make the case for funds for your expert if you're unable to pay the expert to get him to, put together a fulsome affidavit.
But post-trial, you don't have a constitutional right to funds for an expert. And so you have to make some sort of showing on the record. And I would suggest the defendant made no showing. He just speculated. And again, the judge is the only one who found that he was traveling 50 to 60 miles per hour heading into Central Square. There's no direct evidence that his speed in the rotary was 50 to 60 miles per hour. And the speed limit there is 30 miles per hour. So there's really no basis for the judge to allow this motion. And I get that is the catch-22 if you don't have the funds to do it, but you have to make some sort of, he may be able to is not sufficient. With respect to ineffective assistance, the court's already addressed it, but I would say the concession on speed was a tactical matter. But again, we're left to speculate because there's no affidavit from trial counsel, and speculation is insufficient to support a claim of ineffective assistance of counsel. And again, with the failure to present an expert on vehicle speed, it was merely speculative and therefore not ineffective. And the court didn't address the closing arguments, but I would say that the inferences the prosecutor made were directly from the evidence presented at trial. If there are no further questions, rest on my brief and ask the court to affirm the conviction. Thank you.
Thank you, counsel. Thank you both. We're going to take our mid-morning break. We will be back in about 10 to 15 minutes.
All rise.
Test, test, test. Yeah. I think we're good.
All right, our next case is Mass Landlords versus the Executive Office of Housing and Livable Communities, formerly known as DHCD.
Good morning, Justices. May it please the Court, Peter Vickery for Appellant Mass Landlords, on whose behalf I respectfully request that the Court reverse the dismissal, reinstate the complaint, and remand. Approximately 2 years ago, Mass Landlords submitted a public records request seeking the addresses of applicants for rental assistance. That was on September 3rd, 2021. And the reason for the request was spelled out in the correspondence with the department, and that correspondence forms part of the complaint. And in the complaint, Mass Landlords explained why it was seeking, what the public interest was in seeking these particular records. And the burden, of course, is on the department to demonstrate that it is justified in withholding. There's a presumption in favor of disclosure, and in this case, the reason for the disclosure would be the public interest in finding out the addresses of applicants whose applications were timed out in particular. To be clear, Mass Landlords is asking for the applications of all rental assistance applicants in September 2021, and in particular, including those whose applications were timed out. And the reason
The burden shifts to you, right, once the privacy interest is established?
when there's a privacy interest established, Your Honor, yes.
And do you agree that there is a privacy interest here?
There is a privacy interest. It's a little different, Your Honor, Justice Shin, from other benefits in that usually with benefits or with workers' compensation, the privacy interest is with the applicant, which is where the benefit falls. With rental assistance, including emergency rental assistance, RAFT, and so forth, the benefit actually falls not on the applicant, but on the property owner, the landlord. And the other difference is the reduced expectation of privacy with the applicants in these particular categories of rental assistance. The state, through its application form, and its agent, through its application form, made clear to applicants that they would have a reduced expectation of privacy. The state's own application form, which is from page 100 onward in the record appendix, shows that the state was advising applicants that the information, including their addresses, would be shared with landlords, obviously, agencies, also organizations and others. And so the
Is your position that impacts the balancing when we then shift the burden back to determine whether the public interest substantially outweighs that privacy? Is that what it is?
Yes, Your
So you're
Honor.
not saying, though, that notwithstanding the reduced expectation, there is no expectation of privacy. There is a privacy interest here.
Correct, Justice Brennan. Would not suggest that
Would
no
you agree
applicant-
that the government can't waive an individual's privacy interest because they've applied for benefits? You can't waive by disclaimer, right?
I don't believe that the applicants themselves could, I don't believe that the government on behalf of the applicants could waive their privacy interest, but the applicant's expectation, which is the touchstone in the statute, the statutory language is unwarranted invasion of privacy, so that therefore implicates the reasonable expectation of privacy. What expectation of privacy do applicants for these forms of rental assistance, which goes to the property owner whose address Mass Landlords is seeking, as opposed to the applicant? So there is a privacy interest. Most benefits, workers' compensation, unemployment assistance, so forth, do have a privacy interest. I would suggest that the privacy interest here is a little different and lower, and so that does affect the balance.
But you would agree that one could take these addresses and ascertain the identities of people who applied for rental assistance,
Yes, Your Honor,
correct?
and
Okay.
if I should be clear that is one of the purposes set out in the complaint, because the fear of Mass Landlords is that the effect of the government failing to process the applications properly fell most heavily on communities of color, which would be discernible from census tract information, in particularly Black African American communities, and the number of timeouts in one particular month was astonishingly high. It was approximately 67%. So what mass landlords intended to do with this data was compare it with the data of summary process cases that had resulted in evictions for non-payment to determine whether people had been evicted for non-payment when in fact they qualified for rental assistance, but due to the department's mismanagement of the application or failure to process the application properly, those individuals had not been able to pay the money to the landlord, and therefore they were evicted. So yes, Justice Shin, it is possible to discern by comparing the addresses with the addresses in masscourts.org of summary process cases.
So the complaint, in the complaint, it says the plaintiff wishes to learn whether the respondent's failure to administer subsidies led to eviction, and wishes to learn whether the respondent's failure to administer subsidies led to disproportionately lower acceptance rates for people of color. Why is that not simply speculative?
Because some of the census, because unfortunately, Your Honor, judging by census tract information, one is able to determine what the racial makeup of a neighborhood is. So as set forth in the complaint, two things are germane here, Justice Brennan. One is the knowledge that of the African-American black residents of Massachusetts, more are renters as opposed to property owners than whites.
Is that in the complaint?
Yes, Your Honor.
That's alleged. Okay, thank you.
And also the number of renters in a particular census tract, it's discernible what their race is. One doesn't need to know the address of any particular individual for these purposes. The goal here is to determine whether the failure fell most heavily and had a disparate impact on communities of color. And certainly names will be relevant, will be important in determining whether any particular renter, any particular tenant was evicted in hindsight improperly because they qualified for rental assistance. And this, to remind the justices, this is the period after the end of the partial eviction moratorium when evictions for non-payment of rent were just not doable. This is the period after that when an application for rental assistance automatically stayed non-payment cases, which is now in the general laws, chapter 186, section 31. So still it's the case that an application for rental assistance that is pending will prevent the court from entering judgment or issuing an execution. However, some people were evicted for non-payment of rent after the expiration of the partial eviction moratorium, and this is speculative, Justice Brennan. It is a reasonable inference, however, that some of those people who were evicted for non-payment of rent had applied for rental assistance and qualified for rental assistance, but due to the maladministration of the process, did not actually have their landlords receive that rental assistance. So that is the strong public interest in knowing whether this failure to administer the rental assistance program properly and lawfully and efficiently had a disparate impact on communities.
Right, but let's accept that you could use the census data to research that. The allegation that has to be made under Boston Globe is that there was governmental impropriety, which you're saying is a violation of the anti-discrimination laws. And where in the complaint is there that allegation?
There's not the complaint is a public records complaint. It doesn't, it's not a complaint. There is no complaint in the Mass Commission Against Discrimination or EOC.
And the complaint that was filed in the Superior Court.
Yes, that complaint refers to the likelihood of the failure to administer the rental assistance programs properly, leading to perpetuation of racially segregated patterns of housing in violation of the Fair Housing Act and the state equivalent, Chapter 151B. So that is something
But the Boston Globe case says, well, the burden shifts, once there's a privacy interest established, the burden shifts to the requester to prove there is a public interest that substantially outweighs the privacy interest. And when the public interest asserted is some improper action on the part of the government, here you're asserting it's the violation of the anti-discrimination laws, that there has to be evidence, the requester must produce evidence that would warrant a belief by a reasonable person that the alleged government impropriety might have occurred, right? And that's why I'm having a problem, because what the complaint says is that a lot of these applications were timed out, and that might have led to a disparate impact, and that's why we want this information to study that. But to me, that does not show that there is actual government impropriety of the nature that you're asserting.
Well, with respect, Justice Shin, I think that what the complaint does do is suggest that, given the statistical reality of racially segregated housing patterns in Massachusetts and Boston, it is a reasonable inference that any failure to administer the program properly, and parenthetically, the defendant in their motion to dismiss appended an affidavit which states clearly that at least, a conservative estimate, at least 47,000 applications are unaccounted for.
We can't consider that affidavit, right? Because this was on a motion to dismiss.
It was the defendant's affidavit that the...
Right, and they say it was submitted in support of not the motion to dismiss, but in support of their alternative request. And the judge didn't consider it. So let's just assume we can't consider it. I understand what you're saying to be the disparate impact is within the universe of people whose applications were timed out, that there was a disproportionate number of minorities within those. I just said we won't consider the affidavit, the 47,000 applications. Is that what you're saying?
Not quite, Justice Shin.
Okay.
What I'm saying is that the likelihood of there being people within African-American black communities in Massachusetts, in Boston in particular, being on the receiving end of the failure to administer the rental assistance program properly is high. It's more likely than not that a disproportionate number of them were black or African-American.
That's not a violation of the anti-discrimination laws, right? Because it has to be within the universe of people who applied.
Yes, Your Honor. So of the people who apply for rental assistance, all are by definition renters. They are tenants. And in Massachusetts, a higher proportion of the black African-American community.
That's my point, right? So, okay, so there's a higher percentage. So let's say 60% of the applications were filed by whichever group you're talking about, black or African-Americans. If 60% of the applications that timed out were submitted by blacks or African-Americans, that's not a violation of the anti-discrimination law, right? You have to show a disparate impact within the universe of applications.
I think the initial requirement is to show under Communities v. Texas, there has to be some statistical demonstration, but the bare statistic is not enough. So yes, Your Honor. So
what my point is, you're saying because a disproportionate number of black and African Americans are renters, that's enough for you to state a violation of the anti-discrimination laws. And I don't think that's correct, because you have to look at the percentage of people who applied and were timed out.
Yes,
And where
Your
in
Honor.
the complaint is there a non-speculative allegation that there was a disparate impact in that respect?
That's the information, Justice Shin, we don't have.
That's right.
Yes.
That's
So-
right. But Boston Globe says you need to have some reasonable basis to conclude that there was government impropriety. And that's, I think, what I'm missing here.
In the complaint, well, the government impropriety, putting that particular alleged impropriety to one side, the government impropriety, as alleged in the complaint, is the failure to administer the program efficiently at all. The complaint
But
does...
you already know that. We already know that. You don't need the addresses to know that.
One does need to know the addresses to know the effect of the discrimination. The effect of the failure to administer the program properly in accordance with law and dispersing public funds efficiently. So the exact nature, the public has a strong interest in knowing whether the programs were administered efficiently and lawfully. And the public has a very strong interest in knowing, as a subset of that strong public interest, whether the failure to administer them properly led to a discriminatory effect that violates the Fair Housing Act and Chapter 151B. And if there are no further questions, Ron, I rest on the brief. Thank you.
Thank you. Counsel.
May it please the Court. Good morning, Your Honors. Assistant Attorney General Christine Feminari on behalf of the APALE, the Executive Office of Housing and Livable Communities. The Court should affirm the dismissal under Rule 12b-6 below for the following 3 reasons. First, the Court should provide clarity for future cases by adopting a clear rule that the identities of those applying for or receiving rental assistance are protected by the privacy exemption as a matter of law. Second, even if the Court does not adopt such a categorical rule, the addresses of rental assistance applicants sought in this case are still subject to the privacy exemption as a matter of law under the governing balancing test. And third, the Superior Court did not abuse its discretion in denying the motion for reconsideration, which was untimely filed and failed to establish a particular and demonstrable error in the original decision.
Let me just ask you a question. If this case were simpler and it was just a resident, let's say, just John Q. Public, Massachusetts, submits a public record request to the department, wanting to know if a particular 3-family residence in his neighborhood has people living in it that are receiving assistance, what would the response be in a case like that?
The response would be the same, Your Honor, that this information is subject to the privacy exemption because it reveals intimate details of a personal nature that would embarrass an individual of the normal sensibilities. That's the standard for the privacy exemption. In your case, Your Honor, there would be less factors weighing in favor of the privacy exemption because it would only be one individual, and we know from the Boston Globe Media Partners case that when there's multiple individuals' information at issue, the privacy interest is compounded. But we still would argue that there's a very significant public interest because release of the addresses allows an individual's application status that they applied for rental assistance to be made public. And the SJC has made clear that when considering the privacy interest, you have to consider not just the requester's particular ability to identify the individual, but an individual who would be familiar with the subject, the data subject's information. So, Your Honor, in that case, we would argue that it would still be subject to the privacy exemption.
Okay, because I do find it interesting that the statute makes no reference at all to any balancing test. It's pretty clear that what's exempt is data relating to a specifically named individual, the disclosure of which may constitute an unwarranted invasion of personal privacy. So I'm just thinking in terms of you asked for a rule, a particular rule, to enable a custodian of a public record to apply the law clearly and concisely and be responsive to public record requests. That statute's a pretty good starting point, isn't it? The language of the statute?
Yes, Your Honor. Yes.
And as far as the, can you tell us about the, in the balancing test, how would it be different when you're dealing with, and I think you touched on this a little bit already, but how would it be different if you're dealing with something that's very complex here, where you're talking about analyzing data and as far as, racial demographics and so forth? How is the balancing test different here than it is for the example I gave you of just a resident curious about who's collecting public assistance in a house in his neighborhood?
Yes, Your Honor, the balancing test itself is not different in the two cases. It's simply the factors that weigh in favor of either the privacy interest or the public interest in disclosure. So the SJC and Boston Globe Media Partners outlined that there are three main factors to look to determine whether a privacy interest exists under the statute, though other case-specific relevant factors may also influence the calculus. Those three factors are whether disclosures would result in personal embarrassment to an individual of normal sensibilities, whether the materials sought contain intimate details of a highly personal nature, and whether the same information is available from other sources. In the category of records that are rental assistance applications, the personally identifying information of rental assistance applicants, those factors are going to be met in every case. And we know this from the SJC's guidance in the case of Torres, which said that there is an especially strong weight accorded the privacy interest of those seeking public assistance. The SJC also specified in the case of Attorney General versus Assistant Commissioner of Real Property Department of Boston that the types of personal information which the privacy exemption is designed to protect include welfare payments, and such payments constitute intimate details of a highly personal nature.
So you want us to adopt, as I understand it, a categorical rule that information falls under the privacy exemption?
Yes, Your Honor.
So the SJC has plainly said this is a balancing test. So how could we adopt such a rule? Wouldn't we have to essentially be saying in no possible circumstance could the public interest outweigh the privacy interest?
Not necessarily, Your Honor. It would be a categorical rule for the agency to apply to make it more administrable to the
What would the
agency.
rule be? I guess I'm not understanding this argument.
Certainly, Your Honor. The rule would be that the identities of those applying for or receiving rental assistance are protected by the privacy exemption as a matter of law. So,
Right, so I think we're on the same page here, but let's say that a plaintiff comes forward with evidence that's in the complaint that, in fact, there was a disparate impact in the way that these applications were processed. You're saying that there's no circumstance in which a public interest could outweigh a privacy interest?
given the substantial privacy interests here, Your Honor, given the importance that's been emphasized by the SJC, the Supervisor of Public Records, and the legislature in the identifying information of applicants for public assistance, we do think that this is an extremely significant privacy interest that would almost never be outweighed by an interest in a public interest. But, Your Honor, to your point, if an agency has this general rule from the appeals court, then they can rely on it when they're making their determination. Because what's underlying the difficulties here is the interplay between the Fair Information Practices Act and the Public Records Law.
I understand the dilemma, but I mean, the legislature could adopt a specific statutory exemption for rental assistance in similar categories, right? And it hasn't done so.
Yes, Your Honor,
Okay.
but adopting a categorical rule here would allow the agencies to rely on the published opinion and therefore mitigate the risk that they otherwise face.
You might be asking the wrong court for such a rule.
Understood, Your Honor. I would only add that when it reaches the when a lawsuit is brought after this, if the agency relies on a published opinion of the appeals court, then the presumptive attorney's fees and waiver of costs are no longer at play. So that's a big reason why we are asking for such a rule.
Is the public interest here something that is static, that is unchangeable, or does it depend on who's making the request? And this goes to my question as to, does it matter who's making the request? Because if the public interest that we're supposed to be balancing is something static and unchangeable, it doesn't matter whether it's the plaintiffs here making the request or if it's that John Q. Public making the request, right?
Yes, Your Honor. So the public interest is not static. The requester can assert a different public interest in every case. But it's important to distinguish that the requester's particular purpose for requesting the records is not what's relevant. In Boston Globe Media Partners, the SJC outlined that the requester's interest in the records is irrelevant. What matters is the collective public interest that would be served through disclosure. So in one case, it could be, that the government's not administering a program properly. In another case, perhaps there could be allegations of discrimination. So there could be different public interests in that sense, but it would have to be a collective public interest that would be the same regardless of which requester is making the request. And here, Your Honors, applying the standard balancing test, the complaint simply does not establish a a public interest that substantially outweighs the privacy interest here. Opposing counsel has conceded that there is a privacy interest here, and I would note that for the weight of the privacy interest, first off, that the disclaimer that's referenced is not before the court because it was not attached to the complaint. It was submitted to the court as an attachment to plaintiff's opposition to the motion to dismiss. And as Justice Shin correctly noted, while we did submit an affidavit with our motion, it was expressly not for the motion to dismiss. It was to only be considered on the alternative motion regarding FIPA relief. So those facts should not be before the court. Even if the court were to consider the disclaimer issue, the SJC in Champa has mentioned that it shouldn't be the case that agencies can paper themselves out of their statutory requirements. So just because there is a disclaimer doesn't mean that you can get out of the ordinary requirements to disclose or keep secret.
It's a little curious that there's so much factual material in this record that we're supposed to just pretend doesn't exist. I notice pleading it's stricter now than it used to be, but there's some leeway involved in a motion to dismiss, right? So wouldn't you essentially have to show that the plaintiff pleaded itself out of court?
I don't believe so, Your Honor. I believe the standard is that there would have to be plausible allegations made that would allow for there to be...
There have to be enough allegations, but if, evidence could be developed that would support the allegation, that would be enough to get you past 12b-6.
Perhaps, Your Honor, but that's not the case at all here, given the allegations. The allegations are attenuated, speculative, and based on a presumption that is factually inaccurate. Opposing counsel argued, and the Superior Court below rejected the argument that the information at issue here is that of the landlord rather than the tenant. It's the tenant's personal address that's at issue here. So any allegations that there's disclosure on that ground should be ignored. But additionally, Your Honors, the allegations are simply that they wish to study the application process and see if there might be some type of discrimination. There's no allegation that there was any sort of government impropriety here. There's no allegation that there's any sort of disparate impact between groups that were served here. It's all entirely speculative. And as Justice Shin pointed out during opposing counsel's argument, Boston Globe Media Partners has emphasized that that is insufficient. That court found that the requester must establish more than a bare suspicion in order to obtain disclosure. They must have facts that would warrant a belief by a reasonable person that the alleged government impropriety would have occurred. Here, Your Honors, there's no public interest that's asserted. And even if there was, it would not be sufficient to plausibly allege that it could substantially outweigh the public.
Let me just go back to that because I'm intrigued by this because if I was sitting as the public record officer in a state agency and I'm reading the statute and I receive a request for information, it seems that the statute prohibits me from making inquiry as to what the purpose is for the request. It's quite explicit. A records access officer may not require the requester to specify the purpose for a request. Here, you had a requester that did specify a purpose, apparently anticipating this balancing that would be going on. But I'm just curious, how do we reconcile a statute that's telling a records officer that you may not inquire into the purpose for the request? How do we reconcile that with the SJC then saying there's a balancing test that the records officer must undertake. So in other words, if you receive this request without any explanation for what it was for and just denied it, how would that be different than where we're at now?
That's exactly the conundrum that agencies are in, and that's why we would ask this court to pronounce a categorical rule that could help agencies. Because as you noted, Your Honor, they can't ask for more information about the public interest in disclosure. They just have to look at the records themselves. Here, the agency looked at a supervisor of public records opinion, which had previously advised them that rental assistance application information should be private. They looked at the SJC cases, and they concluded that they should be private. But they still are at risk of a public records lawsuit and the resulting fees. Your Honors, I see that my time is about to expire. Unless there are any further questions, rest on a brief and ask you to affirm.
Okay. Thank you, counsel. Thank you both. The case is submitted. All right, the next case is, I'm sorry, let me just wait for counsel to. All right, the next case is Kenneth James O.T. That's correct. Okay. Versus Commonwealth of Massachusetts, number 2022 P599. Attorney Schneiderman?
That's correct, Your Honor. Thank you. 2 for 2. May it please the Court, I am Joseph Schneiderman. With me is Maurice Poe. We represent Kenneth Odie. And our computer is asking us questions. I beg the Court's indulgence. Mr. Odie has plausibly stated a claim for compensation under Chapter 258D on grounds tending to establish his innocence because Sonia Farrick's odyssey of extensive and indeterminable misconduct fatally and fundamentally undermines the accuracy and reliability of the drug testing that underpins his convictions, and that's why his convictions were set aside. Your Honors, the Commonwealth is correct that 258D is a limited waiver of sovereign immunity, but 258D is also a remedial statute. It is there to redress private wrongs, which is the long history of the Commonwealth's moral obligation to recompense the wrongfully convicted. And grounds tending to establish innocence may include fundamentally flawed evidence of guilt or false inculpatory evidence. And as the SJC has made clear in cases like Drumgold, when it goes to the central issue in the case, those are grounds tending.
Drumgold was an ID case, or was the Drumgold, actually, I take that back. Let me just ask a question instead. Is your position that we should take the position that every Farrak or Dukin defendant is entitled to relief under 258D?
At this threshold stage, Your Honor, that is the position. They may have trouble getting past summary judgment, they may have trouble at trial, but at this threshold juncture, the motion to dismiss for failure to state a claim, yes, we should take the position that a Farrak defendant or a Dukin defendant, if they've timely brought a claim, because this is a while ago now, I think that's what Your Honor might have been getting at, if they brought a claim, then yes, they should survive the motion to dismiss. Moving into the merits, courts always look to the rationale. Actually, I think, Your Honor, that's something you might have been driving at here, which is the SJC's decision needed a legal rationale to implement the global remedy. And the legal rationale was that discovery violations that completely thwart a defendant's ability, particularly intentional ones, to prove a fair trial and, by extension, show his innocence, presumptively result in dismissal with prejudice. To the extent that the motion judge overlooked that and focused on the remedy as opposed to the legal underpinnings of the remedy, that's error. That actually goes back to Drumgold and was reaffirmed in Peterson that courts are always can and should and must be looking at the legal rationale for why a conviction was set aside. So here the motion judge didn't do that, and here on this record there is enough to plausibly allege Mr. Odie's innocence. First, Sonia Farrick's misconduct makes the reliability of the testing of any cocaine fundamentally flawed. In CPCS versus AG, the SJC pointed out that by 2009, she was tampering with and stealing the cocaine standard. That's how testing would proceed. That is mentioned explicitly in the SJC's decision at page 707. Sonia Farrick's drug of choice was also cocaine. That's the same drug that Mr. Odie is alleged to have distributed here. Mr. Odie's case thus will turn on whether he in fact distributed cocaine, and the extensive and indeterminable misconduct deprived him of challenging or contesting that. To the extent the Commonwealth is asserting that Calise somehow validates or vindicates them, the Commonwealth is comparing apples and oranges. Calise dealt with equity. The court in Calise was concerned with whether or not someone who was a Farrick defendant, who had the Farrick conviction set aside, deserved credit for time served. That because there is a strong presumption against dead time, as the court made very clear in Calise, the court, though, had to look to equitable considerations rather than Section 33A or the statutes governing credit for time served. Here, though, Your Honors, we're not in equity land, we're in law land. The question is whether or not the legal grounds in the SJC's decision in CPCS versus AG tended to establish Mr. Odie's innocence. And as I suggested a moment ago, because it's intentional and bad faith deprivation of the main evidence, and Mr. Odie and every other defendant like him could not demonstrate their innocence, they deserve to proceed. Your Honors, this was...
Let me ask you this.
Certainly.
In the usual course, because the Farrick and the Duquesne case, they were extraordinary cases.
Mm-hmm.
But in the usual course, we call upon our courts to adjudicate one case at a time.
Mm-hmm.
And that is the usual course for many defendants who seek to overturn a conviction.
Mm-hmm.
That didn't happen here. This was, as you pointed out, it's a global resolution. So there was no adjudication as far as Mr. Odie went. But doesn't 258D really presume that there was an adjudication on the merits for a particular defendant?
Your Honor, I think if 258D was written narrowly, which is what I think Your Honor is driving at, correct me if I'm wrong, to say that we have to look at a case-by-case adjudication, there would be some language in it. I think to impose a gloss like that would be to add words to a statute, and courts interpreting statutes do not add words that the legislature has not put there. Case in point, Commonwealth versus Calvera, 476 Mass. So I think even though the historic import of cases have been individual adjudications, like Mr. Drumgold's motion for a new trial, like Mr. Guzman's motion for a new trial, or like how this court has reversed the Irwin conviction or the Peterson conviction. The court should not be focusing solely on the fact that it was a global remedy, but on the legal rationale for it. That's the teaching of Drumgold. That's also the teaching of Peterson, which is that the courts look to the legal rationale. And I think to focus on global as opposed to individual is a gloss, or it may put the cart before the horse.
So let me ask, appreciating that,
Of course.
as you say, credit for time served is a very different area. How do we get around the language in Calise that says lab misconduct is not probative of actual innocence? That's, I don't know if that's verbatim, but it's pretty close to it.
I appreciate that, Your Honor. Yes, credit for time served is a different case. There's also the strong countervailing policy that was at play in Calise against banked time. So the court was kind of stuck between Skilla on the one hand, which is defendants serving dead time, and Charybdis on the other hand, which is banked time. So I think in the middle, though, is the legal rationale. The court in Calise didn't have to confront the legal rationale underpinning the global remedy. And here, the legal rationale underpinning the global remedy goes far back. Indeed, that issue, this court recognized in 1993 agree in Commonwealth versus Sassville that when there is a deprivation of the main evidence and a defendant has no ability to exculpate himself, the presumptive remedy is a dismissal with prejudice, and that's what ultimately underpinned and led us to CPCS versus AG. Your Honors, to the extent the Commonwealth is asserting some sort of a pleading defect, first, the motion judge resolved this on its merits. The amended complaint, I think, addresses the Commonwealth concerns, particularly in light of Your Honor's concern in the prior case about notice pleading. Mr. Odie opened those allegations up in his amended complaint. He had the right to file an amended complaint because there wasn't an answer. And if necessary, we would seek leave for a second amended complaint if our complaint is restated to further beef up those allegations. Unless Your Honors have further questions, I thank you kindly for your time.
Seeing none? Thank you.
Thank you.
Attorney Leland?
Thank you, Your Honor. May it please the Court, Shannon Leland, Assistant Attorney General, appearing on behalf of the Commonwealth. I'd like to focus my arguments on the two independent bases that this Court could properly affirm the dismissal below. I'll start with briefly with the first one because it's more direct, and that is that Mr. Odie's complaint fails to state a claim under Rule 12b-6 because he omitted the very centerpiece allegation of any 258D claim, which is the person is innocent. And
Bit of a catch on all of these where someone pled guilty, right? Because presumably in a formal proceeding in the Superior Court under oath, he said, I'm guilty and I plead guilty because I'm guilty and for no other reason, or words to that effect.
I have not seen that colloquy, but presumably that is what occurred. And the complaint itself, instead of alleging that he's innocent in any direct way, uses this cryptic language that he did not, by any misconduct or neglect on his part, cause or encourage the prosecution for the offense. That's fundamentally different from saying I'm innocent, which is the true purpose and centerpiece of a 258D claim. Having been put on notice of that pleading deficiency in our motion to dismiss, Mr. Odie filed an amended complaint wherein he repeated that exact, I call it cryptic language, kind of circular language, that he didn't encourage his prosecution.
Well, what about the allegation in the amended complaint that the aforementioned grounds tend to establish that he is in fact innocent? Why isn't that enough under notice pleading?
Thank you, Your Honor. Mr. Odie conflates or confuses or mixes the two steps. Step one is, does he meet the threshold eligibility requirement under 258D? And that is, does the decision that reversed his conviction, does CPCS tend to establish the innocence of the individual, of Mr. Odie? The substantive test, assuming he meets that hurdle and we proceed to discovery, is a much higher bar where he has to actually prove at trial by clear and convincing evidence, not a preponderance, that he is actually innocent. So by Mr. Odie saying that in his complaint that the grounds tend to establish his innocence speaks to his eligibility, not to the substance of the claim.
Well, I mean, don't we look at the complaints with some leniency under notice pleading?
We do look at the complaints with some leniency, but at the same time, Your Honor, it's the Commonwealth's view that it's really no different from a breach of contract claim failing to allege a breach, or a negligence claim failing to allege a duty. He had the opportunity to amend. He took the opportunity to amend. He did amend, and the deficiency remains. I'll also point out to Your Honors the record appendix, page 96. The innocence issue is even muddied more, where Mr. Odie argues that even if he did distribute cocaine, Sonia Farrak may have consumed or destroyed it. That is very counter to a claim of innocence. And I believe on that same page, Mr. Odie argues that he lacks evidence as to whether or not he distributed cocaine. So those things all kind of go to this failure to state a claim.
You're saying there had to have been an allegation of some sort that the substance that I was convicted of distributing was not, in fact, cocaine?
I'm sorry, I couldn't hear you.
There had to have been some sort of, you're saying there had to have been allegation in the complaint to the effect of the substance I was convicted of distributing was not, in fact, cocaine?
I don't think it had to be that specific, but it should at least say or indicate, I didn't do the thing I was convicted of in some language that would meet that element of the claim, the critical element of the claim. If the court has no further questions on that, I'll move to the 12B1 issue.
Is there a case that says whether this is a 12B1 issue or a 12B6 issue?
The pleading issue we are taking as a 12B6 issue.
Right.
The actual standing and jurisdiction issue is under 12B1.
Is there a case that says it's a jurisdictional issue? I'm just, if you don't know, then that's fine. I'm just curious.
I don't know offhand, but I'm confident there is, but I can't give you a citation. The eligibility, which is the test we're at now, the stage we're at now procedurally, this court is to ask the question that is very narrow, which is, does the CPCS decision tend to establish that Mr. Oti did not in fact possess with the intent to distribute cocaine in July of 2007? The legislative history makes it clear that this is a high bar, and the Guzman case explained that legislative history. The initial draft of the legislation said on grounds consistent with innocence, which is a broader pool. And at the governor's behest, the legislature raised that test to on grounds tending to establish innocence. Guzman said it needs to directly implicate innocence, and that the change was, quote, plainly intended to limit the scope of people who are eligible for Chapter 258D. This is a waiver of sovereign immunity, so it's narrowly construed and stringently applied. The test is a backward-looking test. It does not have to do with the hypothetical success at retrial or with what the other evidence is. Per Peterson, Riley, and Guzman, we look at the CPCS decision. Importantly, Peterson held convictions that are reversed on procedural or evidentiary errors or structural deficiencies could well be consistent with innocence without having any tendency to establish it, and that court actually italicized and emphasized the word any. That's what this instant case is, Your Honors. CPCS did not rest on any facts or circumstances probative of the proposition that Mr. Oti is innocent. It provided a remedy of last resort for egregious, undeniably egregious government misconduct at multiple levels. There was obviously Sonia Farrak's misconduct, and then there was the prosecutorial team who failed to disclose exculpatory evidence that was unearthed after Sonia Farrak's vehicle was searched in 2013. CPCS is a sanction, it is a punishment, it is a deterrent, and it is a prophylactic. That's what the decision says. There were no findings about the guilt or innocence of any of the 20,000 defendants. Calise punctuates Mr. Oti's lack of 258D standing. It was under a different statute, the good time credit or dead time credit rule, which is not strictly construed because it's not a waiver of sovereign immunity. So Calise actually had more wiggle room, for lack of a better word, than the 258D sovereign immunity waiver. And the SJC held, quote, "We have previously recognized the egregious misconduct at multiple levels of government in connection with the Amherst Lab scandal. We do not, however, accept the defendant's invitation to equate government misconduct with actual innocence." That controls. Even though it's a different statute, that language is tightly applicable to the circumstances here. And Your Honors, the cases, the leading cases that are cited in our briefs, both mine, ours and Mr. Oti's, catalog cases that have a common thread. The cases that have found 258D eligibility primarily are Guzman, Drumgold, Renaud, and Santana. The first three of those deal with some kind of faulty or frail identification evidence. Either the witness had brain tumor that caused blurred vision, and that was the identifying person, or there were witnesses who were not called who would have said, this isn't the guy who did it. Those are grounds that tend to establish the innocence of the individual. The cases that have not found 258D eligibility are other kinds of reversals on other types of bases. So for example, in Peterson, which I think is a tight case here, there the defendant, now plaintiff, was charged and convicted with possessing a dangerous weapon, the dangerous weapon being a knife. He raised two arguments for reversing his conviction. One, the knife was obtained in violation of his Fourth Amendment rights pursuant to an unlawful exit order. It's fruit of the poisonous tree. It should never have been admitted. Two, it wasn't a dangerous weapon anyway, because the knife itself didn't have the characteristics that fit within the statute. The SJC reversed his conviction was reversed on the Fourth Amendment grounds that did not touch on whether this knife was a dangerous weapon. When Mr. Peterson filed a 258D claim, the SJC said no, that the fact that the police violated his rights is government misconduct. It should have been suppressed. It doesn't establish or tend to establish that Mr. Peterson is innocent. He was ineligible for Chapter 258D relief. Now, had the court rested its decision on the other ground of whether the knife was a dangerous weapon, Judge Gantz's concurrence suggests that the outcome might have been different. Here, the Peterson case is quite similar to the case at bar, and it's our position that it would it would mandate affirming the decision below. Riley is also a critical case to consider because there, the defendant, then 258D plaintiff, had his conviction reversed because he didn't have the opportunity to cross-examine witnesses against him. His conviction was reversed. He was retried and acquitted. And after he was acquitted, he filed a 258D claim with an acquittal in hand. And the court still said, the basis for the reversal of your conviction does not tend to establish your innocence. You are ineligible for Chapter 258D relief. A similar discussion can follow with the Irwin case and Cruz case. Procedural errors, sanctions, police misconduct, government misconduct, those things are in the Venn diagram of reversals, are in the big circle. And in the little circle is those cases where a person is eligible for Chapter 258D relief. Every reversal doesn't yield 258D eligibility. If the court doesn't have any questions, we are happy to rest on the briefs and ask the court to affirm the decision below on one or both of those bases.
Thank you, counsel. The case is submitted. All right, our last case is Daniel Knight versus the Attorney General, number 2022 P765. Attorney Zepka.
May it please the court. Okay. Good morning, my name is Attorney Zepka. I represent Daniel Knight, and I would just like to parlay off my brother's case before us here. This is a same situation where it is a Sonia Farrak defendant who has sued for a 258D under the erroneous conviction statute. And our argument is simply is that the Commonwealth doesn't allow for the case to proceed beyond the discovery stage here. In regard to that, the Commonwealth files a motion to dismiss, and it doesn't give the ability of the defendant here to conduct any discovery in regard to this case. And it also doesn't allow the defendant here any ability to really progress to the next stage here, Your Honors. And the reason being is this is a gatekeeper statute here. In regard to the threshold here, Your Honor, of the 258, it requires that there's three circumstances met. One, that there's grounds which tend to establish innocence here, Your Honor. And in regard to the Commonwealth, they set forth a motion to dismiss, and the judge ruled that we cannot proceed simply based upon a jurisdictional bar here, which it doesn't allow the defendant here to present any arguments in regard whatsoever in relationship to just have a second here. Sorry, I'm nervous.
Let me ask you a question, maybe just to orient you a little bit. How is this any different from a defendant, an individual defendant who is claiming that the government engaged misconduct by losing evidence, by destroying evidence, well, exculpatory evidence? And in those cases, pretty clear, unless you disagree, that this remedy is not available.
So I would argue that based upon the government's egregious misconduct here.
So on an individual level, you had just had the, whatever ex-police department engaged in egregious misconduct in one individual case, but that's all you can say. It was egregious misconduct, I was deprived of exculpatory evidence. Do you get this sort of remedy? Do you get this sort of a relief, I should say?
So I think you have to establish that there was actually a substance here, a controlled substance underneath the statute in order to proceed on a conviction here, Your Honor.
And your client presumably pled guilty and acknowledged under oath that there was such a substance, yes?
He did plead guilty.
Right,
However,
and presumably if it's like any plea I've seen at any level, facts are read in, the person under oath acknowledges the facts are true, and then if it's a superior court, where maybe a little more thorough than the district court, they actually ask at the end, are you pleading guilty because you were guilty and for no other reason? And again, under oath, presumably the defendant says yes. So how do you then reconcile with that with this sort of, well, now I'm saying the substance wasn't the substance and I'm innocent?
Well, I believe that in regard to this case here, it may have been that he was young, and like most people in that position here, just pled out to expedite it here.
Right.
However, I think if you read the actual case here, I don't know if he actually had the drug certifications back before he actually pled guilty. I don't know if that really matters because he did plead. However, it was established later on that it wasn't a substance, or it could have been a substance. I don't know.
Let me ask you this. Do you think we're in a different position if your client went to trial, proclaimed his innocence, or at least put the government to its burden, and it's a Farrak analysis?
I think it would have been a completely different analysis here, because then we would have had the drug certifications, we would have had the trial, and then we would have had whether he was convicted or not based upon...
And you wouldn't have someone under oath saying that he was guilty?
That is correct, Your Honor.
Okay.
I mean, he's not in a great position here, and this is not a great case. However, I think that we can focus on substance, being that he was charged with the intent to distribute and possession here. And then once it was determined that the samples were bad or had to be excluded, that removes the necessary element for the conviction. So that's essentially like the same as an OUI statute. If you do not have the intoxicating either drugs or alcohol in your system, they can't convict you based upon, a lack of sleep or, just taking, like say, a unit.
Speaking of OUI, so the SJC's Hallinan case where they essentially said that anybody who took the breath test in a certain period of time presumptively was deprived of exculpatory evidence, et cetera, et cetera. Are they all entitled to the same relief?
I think it's different here in the fact that we can't go back and test the samples. So they were permanently excluded under the decision by the SJC, and they could be tainted. So there is no way to determine whether it was a controlled substance or not at this juncture. I think it really backs all these defendants into a corner here, being that it was a blanket decision. It doesn't give anybody any ability to establish any grounds of innocence here. So it's essentially the court saying that there was government misconduct. All these defendants are out. In our case, even though it's not a great case because he pled guilty, he's in a unique position here where he was only caught with the substance. So there's no other real mitigating factors here. There was no exit orders. There was no additional crimes charged here in relationship to this. It was possession with intent to distribute, and then the possession charge here. So I believe that there's no way that these defendants could be found guilty, found innocent based upon the tainted samples here.
Let me ask you the same question I asked in the other case. Do you believe that Chapter 258D presumes that there's an adjudication in the trial court on the merits of a particular defendant?
I do not believe that you have to have a trial in order to get relief under this.
By adjudication, I don't necessarily mean a trial, but a hearing of some sort where or a judge is hearing the facts of a particular case and making a judgment as to those facts as they pertain to a particular defendant, as opposed to the SJC making a decision that affects 20,000 defendants.
I believe that does limit the defendants here because the judge did not make findings of fact in any of these cases. It was a blanket decision, so the usual course of action would be a case-by-case analysis based upon the facts presented, and then the judge would establish a record, and then that record would become the record of this court in order to establish whether there was actual innocence or not. But I think this SJC decision prevented that from occurring. So it was a good outcome for the defendants in one aspect, but it was also hindering in relationship to any claim of any compensation for anybody that was innocent under the statute because it didn't establish any facts in order for the defendant to proceed here and cross this threshold barrier to get over into the discovery stages and then have an actual litigation. Now, the threshold stage should just be the threshold, and then it should allow them to progress over, so we shouldn't have to establish actual innocence at the threshold stage, just a showing that he potentially could be innocent. So I don't have any further questions.
Okay, let me just
Do you
check.
have any further questions?
Okay, thank you, counsel.
Thank you.
Attorney Batchelor?
Yes, Your Honor. Good morning, Your Honors. Andrew Batchelor, Assistant Attorney General, here on behalf of the Commonwealth and appellant. And we are asking the court to affirm the lower court's dismissal of Mr. Knight's 258D claim. I'd like to start with the first of our two arguments about whether or not Mr. Knight was sentenced to incarceration for at least a year solely on the basis of his reversed convictions. And this is I don't want to make light of it, but it's grammar. It can't be solely on the basis of the convictions if the reason that year sentence was put in place was because of a probation. Only after the probation violation that he was sentenced.
It was still the sole conviction on which the sentence was based, right? Isn't it more plausible that what this part of the statute means is when someone receives concurrent sentences, one of which has nothing to do with the conviction that was vacated later?
That would, I think, maybe be a more plausible reading of Section 2 of 258D, which sets forth an explicit language that limitations on recovery, saying it can't be recovered if there's I don't have the exact language in front of me, Your Honor, but I think that's a more logical interpretation of Section 2, which uses similar but different languages to bar payment of damages to people who are incarcerated for multiple convictions. But in Section 1, subsection C5, it doesn't talk about the convictions. It says incarcerated solely on the basis of the conviction for the offense that is subject of the claim. And when your probation violation occurs, the court is allowed to consider facts that happened after the original conviction. So, Commonwealth Doucette is an example. Commonwealth Doucette is an example of this. That's 81 Mass Appeals Court 740, a 2012 case, and it's clear that the sentencing judge can consider whether the person is a continuing threat, whether there's any other factors that have happened after the conviction that should go to the sentence. Protection of the public, rehabilitation, deterrence, things of that sort. So it is not just the facts that led to the conviction that can be considered, and therefore the 1-year sentence that Mr. Knight received was not solely on the basis of the events that led up to his conviction in 2006. If there's no other questions on that issue, I'll move to the other issue, which is the fact that Mr. Knight is not eligible for 258D relief. He was not granted judicial relief on grounds which tend to establish the innocence of the individual. And this gets to Justice Hodgins' questions that has been asked twice now about whether or not the legislature presumed there'd be an individual adjudication. I would go further, Your Honor, and say the legislature required an individual determination because they wrote individual into their statute. They did not just require granting relief on grounds which tend to establish innocence generally. They required granting relief on grounds which tend to establish innocence of the individual, and that did not happen here. And so there is not a 258D eligibility. And what the plaintiff here is arguing is that that's unfair, that he should have had an opportunity to prove his innocence. And as he said, the CPCS decision was good in a lot of ways, but it denied him the opportunity to seek discovery to prove that he was innocent. And that is a compelling argument, and it is essentially the exact same argument that Chief Justice Gantz made in his concurrence to the Peterson decision. And that concurrence so overlaps with the plaintiff's position that they quoted it in its entirety for the last 2 pages of their brief on this subject, setting forth the dangers, according to Chief Justice Gantz, of how 258D is written. And to be clear, Chief Justice Gantz joined the rest of the court in finding that Mr. Peterson was not eligible under 258D. But he then went on in his concurrence to warn that a lesson learned from this appeal is that in the absence of corrective legislation, appellate courts in criminal cases need to be mindful of the practical consequences of not reaching a defendant's claim that the evidence at trial was insufficient as a matter of law. It then continues, if Peterson is correct that his possession of the knife was not a crime, the unintended consequence of the appeals court not reaching the issue of the sufficiency of the evidence might be to deny him compensation to which he otherwise might be entitled for a wrongful conviction. So that's how the statute's written, and that's what we have to apply, the law as it's written. And Chief Justice Gantz raised that issue in 2017. 4 months later, Chapter 258D was amended in numerous ways not to change this issue. This issue remained the same. And then a few months after that, the CPCS decision was issued, again, joined by Chief Justice Gantz. So the court knew what it was doing. We're working with the law as it is written. And there is not an entitlement that everyone be able to prove their innocence. For Mr. Peterson, for Mr. Riley, and numerous other defendants, that was not enough. Going to some of the other arguments raised by plaintiff's counsel, where he set forth that, with the conclusions about the drugs tested by Farrak, that there won't be enough evidence for, he would be able to prove his innocence at trial. There wouldn't be enough evidence for, I believe he referred to, a necessary element of the claim. And I would say, first, that argument is misplaced. The 258D statute and the jurisprudence interpreting it don't look to whether or not you'll be able to prove innocence, or whether or not the defendant could prove convictions, prove guilty if the matter were retried in a criminal court. As noted earlier in Riley, he was actually found innocent in the retrial and still was not 258D eligible. So the question is never, could this person be convicted again? At this initial stage of eligibility determination, you just look at the language of the decision that reversed the conviction, and you look to see if that was granted on grounds which tend to establish the innocence of the individual. And so first, it's the wrong question, and I suggest we shouldn't spend a lot of time on it. But to address it briefly, the case law is clear that people can be convicted without a drug cert. So one example of that would be Commonwealth versus Cooper, 91 Mass Appellate Court 595, 2017, which says, proof that a substance is a particular drug need not be made by chemical analysis and may be made by circumstantial evidence. So there are other ways that a drug conviction can be proven without the cert. It's very rare. The courts are acknowledge that it's not a common occurrence, but it is possible. And we cannot categorically say that it would have been impossible to convict any of the Farrak defendants without that drug cert. More importantly, getting back to my first point, it doesn't matter what we can say. The SJC didn't say it. The SJC, in its CPCS decision, did not go on to say that because of this, this misconduct, because of the lack of reliability of the drug certs, it is therefore insufficient evidence to support these convictions, and they all must be vacated. It didn't go to that step, and because of that, it wasn't based on grounds which tend to establish innocence. And in all the cases where the SJC has found 258D eligibility because of insufficient evidence, it actually says there was insufficient evidence to support a claim. And that's what the criminal reversal decision would say. There's insufficient evidence to support these convictions, therefore they must be reversed. Then, when the 258D civil action is brought, that insufficient evidence could be, there's no categorical rule as set forth in Renault, but there could be a possibility of that it was on grounds, as was the case in Renault, which tend to establish innocence. But again, that's based on a specific finding of insufficiency of evidence. And when the court doesn't go that far, as happened in Peterson, where it says there's an unconstitutional exit order, we're going to stop there. When the court then doesn't reach the questions of sufficiency of evidence, then there is no 258D eligibility. Very briefly on a question raised by Justice Shin earlier, I also don't know whether, I can't come to mind where a 12B1 standard has been applied on a motion to dismiss in a 258D eligibility case. It's often on motion to dismiss, sometimes another standard. The most recent Cruz Appeals Court decision in 2023 does refer to this as a jurisdictional issue, but it did get to the appeals court on a summary judgment record. So I do believe it is jurisdictional, but I don't have a case specifically saying it's a 12b1 standard, and there are some cases where it was brought under 12b6, although candidly, I think the same outcome would result here either way. If there's no further questions, I think I'll rest on the brief, but thank you all very much.
Thank you, counsel. The case is submitted, and that concludes our session. Thank you to our court officer, our timekeeper, the rest of the court staff. We are adjourned.
All rise. Gold standard recess. Great to see you all.